All right, good morning, everyone. Welcome to the December 7th development meeting. We will call the meeting to order. Roll call, please.
Member Krajewski.
Here.
Member Covert. Member Garcia.
Here.
Member Ozog. Member Rutledge.
Here.
Chair Tornatori.
Here. And we have a quorum. I'm going to ask for a motion to amend the agenda and move the informational items and item 7 after we do the regulatory items on item 8 so that we can move the matters along more efficiently. Is there a motion to do so?
So moved.
I'm going to move 7A and B after we do 8A, B, and C.
Okay.
So the adult cannabis discussion will take place after we do the other. It'll give us more time. There's a motion. Did I hear one?
I've made the motion, yes.
Second. All in favor?
Aye.
Any opposed? And the agenda is amended. Okay, we'll move on to public comment. Public comment is limited to 30 minutes. Speakers are limited to 3 minutes per person at the beginning of the meeting. Any comment on zoning items are limited to discussion of testimony that was previously presented at the Zoning Board of Appeals. Just so everyone understands, there's no new testimony or evidence that can be presented that wasn't presented previously. You may comment on what you know or feel about a particular item, but we do not take into consideration any new evidence. That being said, we will move on to the first person who signed up for public comment. That is Connie Smith. Connie, are you here?
I am.
Okay, please feel free.
And do I just stand here?
You can stand there, sure. I think whatever works, I think that's good. And you got 3 minutes. Sure.
Yes, okay. All right, my name is Connie Schmidt. I live in Warrenville, Illinois. I'm a DuPage County citizen for the past 40 years. And I'm here to speak out against the request by Halliday for the property in Warrenville along Butterfield Road. I've been a horse keeper here in Warrenville for 40 years. I have respected the requirement of the county ordinances that there be 1 acre for the first horse and a ½ acre for each additional horse. That means if you're generous, almost 3 acre parcel could accommodate 5 horses. Ms. Halliday is petitioning to have 8 horses, but also 36 ponies, assorted alpacas, goats, sheep, and a sundry of other animals, totaling well over 80 animals on this less than 3 acre parcel. This vastly exceeds the allowance for a residentially zoned property. It is concerning that other horse owners in Warrenville and the surrounding areas could be lumped into a category with her, that we are an inappropriate atmosphere in and around Warrenville because of any negative impacts that property could have. We value being respectful members of the community. In addition, this is a commercial business with a variety of trucks and trailers to be coming and going from the property. Again, inappropriate for a 2.9 acre space in a residentially zoned property. I'm well aware of the cost and labor to remove manure from 5 animals. 80 plus is going to require staff and of additional assistance to help with this venture. And this is going to add to that daily traffic of this commercial business on the property. I did some research, and Miss Halliday seems like a nice person. Reports from Horse Friends in Cook County are that she cares about her animals, but claims on her website that she is a USDA approved business are inaccurate. The office has been called, and Miss Halliday did not recently, and she herself did phone in some inquiries in order to be approved, but she does not currently hold any USDA approval. With these concerns in mind, and with respect for the current neighbors of the property, which includes the DuPage County Forest Preserve, who was assured that no business will take place on that property, and with the concern for the private home that is just to the west of this venture, I really respectfully ask that you deny the request from Ms. Halliday. And I thank you so much for your time.
Thank you, Connie. Next person, Sue Goldston. Sorry about that, Sue. Okay.
Hi, good morning, everyone. My name is Sue Glistane, and I live at 27W344 Butterfield Road. I am directly across from the property that's requesting to be rezoned. I would like you to please vote no on this as well. Butterfield Road is known as State Route 56. It's a major road with a large volume of traffic consisting of semis, trailers, school buses, bikes, and daily commutes. I've lived at my property for 15 years. I have seen near misses and accidents as from cars turning, from speeding, everything near my property. One of my concerns is safety. With an increase of trailers going in and out of the property, we will see a substantial increase of impeded traffic from the school buses that are going to Hubble, that are going to the Leechbrook Elementary School, as well as going to the local high school. Semis also consider Butterfield Road a commonly used route. I have seen many instances of my kids getting on and off the school buses, and daily commuters are jumping out behind the school buses in front of the semis and other drivers. At least once a year, I have seen a car in the grassy median. The trailers will be a massive hindrance on an otherwise busy street. The funnel effect of drivers switching lanes will increase the likelihood of an accident. During inclement weather, my small driveway is blocked. It's encased by a block of snow. Those snow plows, they pretty much just close off the end of my driveway, and this leads to traffic issues. It leads to congestion. That whole funnel effect just causes erratic drivers. The visibility issues and the challenges of exiting and entering my driveway increases tenfold every time I have that snowbank at the end of my driveway. It hampers me getting in and out, and it will hamper that drivers trying to pass the animal trailers. The animals trailers carrying the animals to and fro disrupt the ongoing traffic, including the daily route taken by the school buses. In addition, at least 4 times a year, we have a loss of power. So this power can potentially hurt the animals. If we have any kind of blizzard, any kind of heavy snowfall, there's nobody going to be living at that residence, and those animals could be at risk if somebody tries to get there and help them. The property across the street at 27W344 Butterfield Road is not appropriate for a business with a large head count of animals, and it creates a safety issue as well as generated waste, noise, and smell that could lead to a decrease in my property value. I have here a chart that we put together looking at scenarios. These scenarios range from 1 to 13. It looks at the number of horses. It looks at the square footage required for horses, the square footage required for alpacas, for sheep, for llamas, for different kinds of counts.
So I'm going to ask you to wrap it up, please.
Okay. So this will show you that each one of these scenarios is a problem in terms of the federal guidelines of how many animals could be at this property. Thank you very much for your time.
You're welcome. Thank you. Steve, I'm sorry, Borowiak.
Broviak, yes. Well, I am Steve Broviak. I'm the next door neighbor to the property. Just to let you know, I'm a USDA accredited veterinarian. That's the United States Department of Agriculture. For the last 30 years, I've worked at Cosley Zoo, DuPage Animal Control, and I currently have a petting zoo that I work with at White Fence Farm. My 2 concerns is the statements that were made. The ZBA approved votes in favor of the conditions. 2 things on the conditions that were false statements. One is that there is no municipal city water or sewer to the site. What this means that all the refuge, whether it be human, animal, or truck vehicle, is going to drain into the soil that's there, and then it would continue west towards the forest preserve of my property. The other concern I have with the statements that were made in the ZBA conditions is that at the initial hearing, the petitioner testified under oath the list of animals to the site. These conditions were changed in the ZBA recommendations. Their list changed to miniature goats, miniature sheep, miniature llamas, and miniature alpacas. I, as a veterinarian, don't understand exactly what that means, but I think it was not the testimony that the petitioner gave. The other thing is, any other USDA has a license. I'm licensed to be able to go ahead and have animals in my home, and it includes the health and safety issues of the animals are the most important. Every animal needs daily access to fresh air, sunshine, and exercise. She states that she has a USDA permit. Unfortunately, I have not been unable to locate their current USDA license, which is required for the petting zoo. The site shows that the license was canceled in 2019. I would also ask that you guys consider, as far as the value of my property and the noise and the smells and everything else that goes along with it. Thank you. And I have one other comment. I was thinking this was going to be resolved and didn't realize till yesterday that I had not have my council present. I would like to have my council present if this continues on.
Well, I don't know what we can do about that, but we're gonna decide presumably today what we're going to do in this matter. One way or the other will be referred to the county board. And if you want to have your counsel there to have a public comment, you can. But again, no new evidence is presented as we move forward. Next, Amelia Ingram.
My name is Amelia Ingram. I'm part of the fire department for Warrenville. We do have a lot of traffic that goes down Butterfield. I've been on plenty of accidents that have happened on Butterfield Road there. Some fatalities with large trailers going in and out of that area with our young drivers coming in and out at different times. That makes it harder. We have Arrowhead, which is down the street. There are people that have been drinking and driving. We don't want people drinking and driving, but there are out there. So to see a trailer backing in and out and having these drunk drivers, let alone trailers on the road, we want to see less and less of that. But this area to have trailers go in and out, it's not feasible in the area. For our fire equipment to go down that road, our hydrant is across 4 lanes of traffic to get water to the barn. It's over 460 feet, I think, from the road back there. And that ambulance to get down the driveway, if there are trailers in the way, if an employee or let alone somebody visiting the farm gets hurt, it's just harder for us to get back there. Not saying we can't, it would just be trailers out of the way. That's a huge issue for us. It is a business for having that. So business would have different regulations for the fire department to be looked into. And if there's any new buildings or anything else, you would have to go to their terms for a business for having that property. We've had a bonfire in 2018 and we lost the whole barn. Luckily, there were owners on site. I don't remember how many horses, but for the fire and stuff, the owners were able to hold on to the horses and get them out of there. If you do not hold a horse when there is a fire, they go back in. We've seen it. I don't want to see any tragedies happen for this area with 86 animals. Sorry. We also need to make sure there's exits on the barn and how many, and the diesel with the trucks and the noise and unloading, where we put our fire equipment if we are trying to get down there. So if we have trailers all over in there or backing down, we want to make sure that we have area for any of that. Stormwater, they already covered. So we were talking about poop and stuff. I have a 40-pound bag over here. That's how much poop a horse has in one day, let alone 2.5 gallons of urine. So to take all that away, when you have trucks coming in to get rid of the manure, they said that would be removed every single day. So how many dumpsters are you going to need for that to go there? You don't want that, all that urine and that poop to be running off and going into the system. I also am a 4-H'er and a leader. My kids are 4-H'ers, I should say. I was a 4-H'er. And for people to have animals in DuPage County, it's huge for kids. You have something like this come in, there's 86 animals instead of a couple, you're kind of ruining it for other 4-H'ers if there's too much noise or too much poop or not being quality care, because DuPage County will say, you know what, no more animals on this property or any properties in DuPage County because of this incident. They'll read back to saying, hey, the smell, the diesel noise, the accidents, everything adding up. We don't want to take away 4-H to all the kids that are in it and have a couple animals that they're able to take care of.
May I ask you to wrap up if you would, please?
The storage of food and alfalfa and everything else for these animals, that's huge too for our fire incident of where you're going to keep this. The farm fire we did have had a ton of hay and stuff in it, and it took weeks and months to actually have all that stuff go out. So just under a fire safety issue and the community that I live in and protection, I don't want any tragedy.
Thank you. Thank you for your comments. Is it James?
Yeah.
Langle?
Jeff Landau. Good morning. Thanks for letting me speak. 3 minutes, I just have 3 comments, and I'm just hoping there's some common sense here. I live in Arrowhead subdivision, right down the road off of Butterfield, and hundreds of times I drive up and down, back and forth on Butterfield Road, which most of you would assume that that is a beautiful place right now. So number one, I always thought this property was kind of like a gentleman's farmer property, like someone that would have a few horses, build a nice house, live in almost the country, but being in the city. I'm opposed to that changing. My second thing is now I understand that this is going to be a business with no house and housing approximately 80 animals. Thirdly, why in an area set up for the public's enjoyment, like St. John James Farm, Blackwell, Herrick Lake, Warren Grove, Forest Preserve, is this being considered to be changed? The area around there is set up primarily as a forest preserve area for people to enjoy, and not as a business to house 80 animals. So I would have everyone consider not changing the use of this land as it is now. Thank you.
Thank you. That concludes the public
Sir, you
comment.
didn't call my name. I signed up Sheila Wakely, Grace Counseling of DuPage.
I don't have you down here, but okay, Sheila.
Okay, I'll just be brief. My name is Sheila Wakely. I live at 29W463 Amber Lane. I teach at the college and I have a private practice in Warrenville. And I do a side ministry for wounded warriors. I use this path daily. As a matter of fact, I can attest to personally, every single day someone said here, I got hit by a car right outside there by a guy on Butterfield Road without any insurance and ended up in the hospital and almost died. I have seen 2 other fatalities in the last 3 years on the Prairie Path, which has now been designated by the town of Warrenville as official bike path. The amount of traffic, we have set up security cameras to count the number of people that go to Herrick Lake. It has, in 2 years, the population, daily population from it during COVID has gone up 10 times. And that is a fact that you can Google and it's real. Additionally to that, when you rezone a piece of property, I have 8 years of graduate school and I went through the real estate course before I went on to get my other licenses in other parts. This is a very serious thing. I've said at enough county board meetings, I used to live in Glen Henry. I've gone to a million meetings. This is so serious an issue. For somebody that travels that Prairie Path every day, I'm here to tell you, not only will there be a fatality, there will be more than one fatality. I can base this on current facts now. In addition to that, this meeting was changed at very short notice around the holidays. I've been down this disingenuous path many times. I'm telling you right now, yesterday we got 400 names on a petition. And if you gave us 2 weeks, we would have 1,000. This is how strongly people in that area feel about this. And I can personally attest to every single thing that was said here by living proof and medical records to substantiate it. 3 fatalities in 5 years on that bike path. And what you're going to put in there without a homeowner is absolutely criminal, in my opinion. Thank you.
Thank you. Okay, I think that does now conclude the public comment portion of our meeting. And we will move on to approval of the minutes. I'll entertain a motion to approve the minutes of November 16th, 2021. There's a motion and a second. Any additions, corrections, or deletions? Hearing none, seeing none, all is in favor? Any opposed? And the minutes are approved. Budget transfers, I see we have none. So we will skip item 7, A and B, and move on to item 8, regulatory. As you know, our policy is to take all motions in the affirmative. So I will entertain a motion to approve DCO 001-22, ordinance Z21080, Halliday, the zoning board of appeals recommendation to deny a relief for conditional use for a recreational facility generally located east of Winfield Road on the south side of Butterfield Road. We have a motion to approve. There's a motion and a second to approve. Any discussion, questions among the members? Yes, Member Rutledge.
Thank you, Chair Tornatori. full disclosure, for 27 years, I lived directly across Butterfield Road from this property. I applaud the petitioner for her animal services, but I do not think that this is the right property for the volume of animals she is proposing to put there. Traffic, it is a well and septic area, so that's a lot of manure and urine that no matter how diligently she picks up is still going to get down into the septic fields and the wells there. I am a Donata volunteer, so I know full well about that 50-pound bag over there and the amount of manure that is generated. So I do have concerns. The other thing that concerns me about this property is that the Forest Preserve had said that they did not have any issues with this property. And with 8 full-size horses and 30 ponies, I cannot imagine that there won't soon be a path beaten into the Forest Preserve behind this property. So I will be voting no on this issue today.
Vice Chair Garcia.
Yeah, I was just wanting to just really clarify what the zoning law is on how many animals can be on this property. I want to make sure it's real clear on what our zoning code states.
So there's 2 different types of zoning relative to animals
Okay.
and horses and stabling horses and animals in particular. For a single family residential property, the minimum lot size to have at least 1 horse on the property is 40,000 square feet. For each additional 20,000 square feet of land that you can have an additional horse. So for instance, if you had 60,000 square feet, that would yield 2 horses.
Okay.
The second part of that is the zoning ordinance has conditional use allowances for certain types of activities. One of the conditional use allowances is a recreational use, specifically to have stables on a property. When the zoning board of appeals and county board is considering a stable on a property as a conditional use, there is no limitation on the number of animals. The limitation would be based on what the petitioner presents and how the petitioner proposes to operate that stable on the property. So for the conditional use, there is not a limitation. It's only defined based on what the zoning board of appeals and ultimately this committee and the county board feel is appropriate for the property.
Okay. So I thank you for that clarification, Paul. And it's interesting that the zoning classification allows anything to go. As a member of the Animal Services Committee, and all we're doing is fighting for animals' rights, it seems to me just counterproductive to see so many animals going to be going on such a small piece of property on this. I'll be voting no on this because I just don't think it is a fair treatment of the animals. I mean, sure, she might be a very fine owner with the animals so far, but I just think that there's not enough room for the animals to move and to get around and to be taken care of in the best way possible. So thank you so much.
Any other questions from the members? Member Krajewski.
Thank you. So the history of this property, Paul, because the stable's been there for a while, right?
Yes, this property was co-joined with the property to the west about 23 years ago. And there are two properties on the south side of Butterfield Road. One has a single family house you heard from that person today, and then the subject property. About 22 years ago, these 2 properties were combined to form 1 zoning lot. As a combined zoning lot, the properties were over 5 acres in size. Under the Illinois state law and in our zoning ordinance, if your property is at least 5 acres in size or more, you qualify for an agricultural use. Because this property was over 5 acres, they were able to qualify to be able to put a horse barn, riding stable, and arena on this property without any zoning relief and without any building permits. So this horse barn,
22 years ago?
this was about 22 years ago, and this horse barn was built under the auspices of the agricultural use.
Sure.
About 10 years ago or so, the 2 properties split apart, and as a result, each property now is separate zoning lot. As a separate zoning lot, the subject property is less than 5 acres, as is the property to the west. As a result, the subject property no longer qualifies for agricultural use, and the property to the west no longer qualifies for an agricultural use. So what we have today is we have 2 properties that are currently not legal because they're not agricultural uses. And at least on the subject property, we have a 15,000 square foot horse barn that is currently being used to house horses. It has approximately 20 stables. and it's not technically legal right now. The zoning relief that is being asked for in theory would make this property legal.
And it became not legal after the split of the property.
After the split of the properties,
Has
because
there been a lot of animals out there over 22 years?
there have
So they've
on
had,
both properties.
on both properties, they've had animals out there. Okay, and then it was hard to go through because I didn't have all the detail for the actual hearings, but did the Warrenville Fire Department submit testimony at the hearing?
There was no testimony submitted at the hearing from anybody other than the petitioner and the property owner to the west.
Those are the only two.
Those are the only two people that presented testimony and evidence. As a matter of process, staff sends out notification
Right,
to
because I
all the
saw Forest
jurisdictions.
Preserve one in there.
Correct. And we ask the people who would have jurisdiction on these properties if they have any concerns. The Forest Preserve indicated that they didn't through a letter, and the Fire Protection District was sent something. They did not respond.
Okay, so the fire department didn't respond, and then Forest Preserve, I saw the letter. Correct. Okay, and so, I'm looking at this, and it looks like, our conditional use for the property, it says, well, for signs, it says facility, recreational facility / stable. So, I guess it's recreational use, it's one thing, but stable seems to be another. And I think that seems to be the denial.
Correct. The way the zoning ordinance is set up is it has zoning districts. This happens to be a single family residential zoning district. And within the single family residential zoning district, there are permitted uses and conditional uses. One of the conditional uses that's allowed in this single family residential zoning district is a recreational use / stable. So the stable modifies the recreational use. So a stable is a permitted conditional use. To be clear also, this is not a rezoning request. This property is not going to be rezoned. It's simply a conditional use to have a stable as a recreational use on this property.
So I guess I can understand why, they voted 5-2 to deny. I think just some, basically on that kind of the language of the statute.
One of the issues that the main issue that the zoning board of appeals had was that the way the ordinance is written, it talks about a recreational use. The zoning board of appeals had a concern that this is not really a recreational use because there's no recreating going on the property. It's merely to store and house these animals. The stable portion, in theory, would allow that, but the zoning board of appeals got caught up with statutory construction of recreation.
Right. I mean, that's what looks like, and maybe the two that voted for it, it's like, it says stable.
Correct.
That's what we have. We have a stable. The other ones look at recreational. So that being said, then I get into the dissenting opinion. But that looked like it was granting the conditional uses for what's been there for 22 years.
It's
With the limitation on the amount of animals.
correct.
And that one was approved 7-0 by the zoning board. Because it appears that qualifies, and if that goes through 7-0, if it made it through with the conditions here, does that require supermajority at the board meeting?
It does not. Conditional uses don't require supermajority if the zoning board of appeals denies. The only time that supermajority kicks in is if the zoning board of appeals were to deny a variation. Because this is a conditional use, not a variation, that supermajority would not apply at the county board level.
And this conditional use, because Peter went through 7-0, that's fine underneath our rules, just with the conditions we put on. And I noticed, and there was somebody commented on today, we could modify those. I don't know what she said, I guess, in the testimony, the petitioner, that she had miniature llamas or miniature sheep. Just change it to the word sheep, I guess.
Well, to be clear, two things. The zoning board of appeals voted to send conditions to this committee and then ultimately the county board. Given this notion that if the development committee found that statutory construction issue that the ZBA was having really didn't apply here, that this in fact was a legitimate conditional use for a recreational stable. And that's why the zoning board of appeals recommended unanimously on those conditions. In terms of the line item for the types of animals, the petitioner has testified and
Right, I saw the testimony said miniature.
and continues to say that those will be miniature. So that's why the ZBA has tied it to miniature.
That makes sense. But with that, I kind of lean towards the side of the the stable aspect of the statute, but that being said, I would make a motion to do the conditional uses. Which the DBA had no problem with past 7-0, or I don't know if we do that. If you do both, do we deny one and then do a motion to the other to bring forward? That's the state's attorney.
Well,
I mean, we got 2 different recommendations that came through there.
well, yeah, and that's part of the problematic nature of what the zoning board of appeals did, is they said no, but if we say yes, this is what we'd like to have, so.
Because they gave us conditions which can do conditional.
And we
use.
can, correct me if I'm wrong, Paul, we as a committee can approve a zoning request with conditions if we choose to do so, and if it's obviously accepted by the petitioner to recommend to the county board.
That's correct. And these conditions are essentially advisory towards that end.
Right.
Sure, right, yeah, they were advisory conditions, and or do we send it back, the petitioner has to resubmit with the conditions on there?
The petitioner has already accepted these conditions, and once again, these conditions are merely advisory if this committee
Sure, right. No, I
chooses
understand.
to approve the conditional
And we
use.
could change it
Clarify what that
to,
means.
we could change it.
Excuse me, ma'am, we're
I mean, we could change it
right
to
now.
30 ponies or 15 ponies or a
And
limited amount of animals.
to be clear, these are advisory.
Right.
You could change these
Right.
conditions, or you could add conditions.
Yeah, their conditions all seem fine. If there's an issue with the amount of animals, maybe we tweak the animal amounts. But these are the ones that are currently out there, have been out there forever, right?
Well, just to be clear,
What
these
she said.
these animals are not out there now. This applicant is currently operating in Willow Springs.
Okay,
If this zoning relief were approved, well, let me back up. Currently, there's a horse stable there, owned by a different owner, not the applicant. That owner currently has horses on the property. If this applicant were to get the zoning relief, those horses would leave the property, and this applicant would bring these animals on the property from Willow Springs. These animals are not out there now.
was this petitioner doesn't own the property,
Does
right?
not own the property, no contract.
Gosh, okay,
Sorry.
okay.
You done, Brian?
Yeah, that's all I got.
Anybody else have questions? Yes, Morella.
Thank you, Chairman. So again, I lived across the street from this when this barn was being built, and as an avid horse rider then, I was quite excited about the prospect of having a riding stable right across the street from my home. But quickly that agreement fell apart, and I don't recall ever, and I could be wrong about this, that property ever maximized the 5 horses required. So I guess the point I'm trying to make is there was never that many horses over there to my knowledge, and the agreement to make it a boarding stable lasted about a hot minute, months rather than years in my recollection. And so this property has never had the heavy use of what this person is proposing. So that's the point I want to make. Thank you.
Just for
Vice
clarification,
Chair Garcia.
just for clarification, how many animals again are they asking to put on this?
80 total.
80 total.
Yeah.
Any other questions from the committee? Okay, Paul, I'm a little confused as to the definition in our zoning code of commercial versus recreational. Do we have a definition or an example that you can give us? Because I suppose that somebody can be running a business, and part of that business can be for the recreational purposes of other people. So what is that? Is that recreational, or is it a business? I'm a bit conflicted there.
Well, as it relates to agricultural uses, where one can have horses, or cows, chickens, or one could grow crops. The way the ordinance is constructed is that if you're over 5 acres, you can have agricultural farm animals on your property. The section in the zoning ordinance that allows for a conditional use to have a stable was put in there specifically to deal with a situation where if you didn't have the 5 acres, you could petition the county to effectively have an agricultural use on the property, but you don't have 5 acres. That's the real purpose of it. And that's,
But you would be limited to whatever the conditions would be that would be established by the zoning board and not have carte blanche that you would otherwise have under an agricultural use.
that's correct. And that's
Okay.
why that, rather than simply saying stable, so as not to confuse it with, a farm or agricultural use, the ordinance was written with the term recreational. And that is a bit confusing, I understand that, but in order to distinguish between 5-acre agricultural farm that has horses on it, where you have riding activities, and we have a few of those in the county. If you're less than 5 acres, the way the statute or way the ordinance was written was to call it recreation and then to modify it with the word stable. And that effectively allows for a riding stable with, in theory, unlimited horses and animals on the property where your property is less than 5 acres. And
Which
once
can
again,
be used for business or recreation.
correct.
So
And one of the issues here is that the zoning board of appeals had was that there's really not a recreational component. There's not going to be a riding school here. People can't come on this property and ride horses, or they can't come to this property and have a petting zoo. For instance, Cosley Farm, when it was first established over in Wheaton, that was a conditional use to have a zoo on the property, and you had all kinds of animals on the property. It was open to the public. This is not going to be open to the public. There is going to be no even private riding here. This is going to be used solely for the housing of these animals. The person who is proposing this will be living on the property as well, and she will take care of the animals, and any activity associated with the animals will occur off-site. And once again, that's where the kind of confusion is with the zoning board of appeals, is that there's no recreation going on here, but there is stabling of animals here.
okay, well, then that leads me to another question, which because we've heard some comments this morning about no one living on the property. You've indicated it's incorrect.
There are two buildings on the property. There's the 15,000 square foot stable and writing facility. And then there is an outbuilding. That outbuilding, just essentially a detached garage. The petitioner proposes that if she gets the zoning relief, she'll convert that detached building into a residence and live on the property.
Now, when this property was split up, and that was some years ago, was it? You say
Approximately 10 years ago.
10 years ago? Okay. Well, let me backtrack. The proposed owner, the petitioner, or the contract purchaser would be asking for more animals on the property that currently exists now, correct?
That practically exists now.
Okay.
Yes. They've had various different number of animals on both properties over the course of the last 22 years. Right now, I believe there's approximately 6 horses. They've had up to 20 in the last 4 or 5 years in the barn. But in the past, there's been dramatically more animals on both properties in the last 22 years.
And those 20 that currently are there now under the current owner
There are
are,
not 20 horses there now
No, there were 20.
for a very short period.
I mean, or everybody jumps all over. That's my question. Okay. How many are on there now? How many horses? Okay.
And that's
there-
confirmed by the owner of the property.
And under the proposed conditions, there would be
80 animals total.
how many horses?
There would be 8.
Let's see if I have questions. Okay. All right, yes, Member
Two
Rutledge.
more points I want to make is that I don't know that it's been clear that there is a prairie path that moves, that is directly in front of this property. So the ingress and egress of the horse trailers and all of that will impede the traffic on the prairie path. And the second thing I wanted to point out is, which my mind, I'm so sorry. That was the other point I want. Oh, I know what it was. On this person's current website, she talks about doing badges for Girl Scouts and Boy Scouts. Love that she does all of that work. But I also do tours at the NADA for Girl Scouts and Boy Scouts to earn badges. And I can't imagine an animal owner trucking all of her animals to wherever the Boy Scouts and the Girl Scouts are in order to do those badges. So I do think that small groups would be invited onto this property to get a feel for the life of that animal as part of their educational badge. Thank you.
You think they will be bringing them on?
Mhm.
But that's if,
And
I
that's,
can't
and that's,
imagine that
and
they would
that's again,
grab-
but
that's,
that's a
excuse
condition.
me, please, we can't have people coming from other than the committee, and I'd ask the committee members to speak one person at a time, please. So, okay, Sheila, are you?
I am finished, thank you.
Brian, did you have something?
I'll just say that's the conditional use that you put on it. They're not, I mean, if they say they're not gonna do it, you have to put that on as a conditional use.
And that's speculation. Nobody knows.
It is.
We don't
That
know
is
that
true.
because
But
it
that's
hasn't.
what you would put in the conditional use is that if they say they're not gonna do it, then you put it in there, that they can't do it, and then if they do, they're in violation.
Okay. Do we have any other questions from the committee for the petition as it's been presented? All right, so just so I can get a sense, so we don't waste a great deal of time. Is there an appetite among committee members to discuss approving this petition with some conditions?
Well, I would, I mean, that would
Consensus
go
here.
along with the ZBA. I would deny the first one, but I would go along with the ZBA and putting conditions on, because it's been.
Okay. So we have a couple of alternatives here. We can deny, straight denial. We can approve with conditions. Well, correct me, we can deny it and ask that it be sent back to the ZBA, and they can relook at this. And instead of saying no, but here are the conditions, they can make a decision and approve it with the conditions, which is really their task to start with, instead of saying no, but if, and throwing in our laps. So those are a couple of things. I think for purposes of clarification, it, quite frankly, well, my personal opinion, makes more sense to take a definitive position on it one way or the other right now. And if we want to send it back to the ZBA, let the ZBA kick the tires on this a little more, and perhaps with some more information or some other conditions, there might be a different result from the ZBA, and maybe even a meeting of the minds of all the people before, so we don't get conflicting opinions, because I've heard one thing and I've heard other things today that aren't exactly dovetailing together. So if there's no objection, let's take a vote on the petition as it's been set forth. And can we deny it with a decision to send it back to ZBA, or is that going to be a petitioner's decision? Or can we amend the petition and just, well, you tell me.
It would be cleaner if there's an appetite to send it back to the ZBA for further vetting of some of the information we've heard. I know we don't take new information, but we've had some new information. So it'd be cleaner to send it back, to take a vote to send it back, and then take a separate vote to deny, and then take a separate vote to approve with conditions.
Do that. All right. So you want to do the vote to send it back first?
That would make sense. That would.
And that doesn't mean that the petitioner has to re-petition or go back to the ZBA. If they choose to just let it die on the vine, it'll die on the vine, right?
It'll go back to the ZBA, and then the ZBA will take it up at a recommendation meeting to set another public hearing. And so the public will know when the next public hearing is going to be, to vet any additional information that the public wants to provide or that the petitioner wants to provide.
Okay, so I'm going to defer to you, but I'm going to kind of reverse things. I think for me anyhow, in my sometimes illogical mind, I would go the other way around. I would say, let's take a vote to approve and see if that is going to go up or down, and then a vote to deny up or down, and then a vote to send it back to the ZBA.
Fair
Does
enough.
that make sense?
Fair enough. Yeah.
Okay, everybody all right with that? Okay. So we've got a motion to approve on the table. So I think we take a vote on that, then just so we all understand, we'll ask for another motion to deny, and then we'll go with that. And then the third one would be to send it back to
What
ZBA.
about the conditions?
Well, I think if we send it back to ZBA, those conditions we're throwing back into the lap of the zoning board of appeals, which is really where it should be. I think.
Yes. Because the big one is the sheer amount of animals.
Right,
And the
right.
condition, and this condition may be way too many animals. to
Right.
your point, but
And it gives the petitioner an opportunity to maybe pare down what they're asking for as well, without us imposing that. Okay, so we've got a motion on the table to approve the petition which was denied by the ZBA, but again, this motion is in the affirmative. So if you will take a roll call to approve the petition as set forth.
Member Krajewski,
Aye. This is to deny, right?
This is to approve.
Approve. Nay.
Member Garcia,
No, nay.
Member Ozog,
No.
Member Rutledge,
No.
Chair Tornatori,
No. Okay, so the motion to approve is denied. I'll entertain a motion now to deny the petition as set forth by the zoning, by the petitioner, Z21-080.
No, we just did.
Well, we just did a motion to approve it. Now, to be consistent, we should just flip these votes, and so we understand what we're doing. I think we just want to be clear on what we're doing here.
Okay.
It may seem to be somewhat overkill, but I'd rather be overkill than underkill on this one. All right, so there's a motion, is there a motion to deny? Someone?
So moved.
Second.
A motion and a second to deny the petition. Roll call, please.
Member Ozog,
So if you want to deny this, you vote yes this time. You voted no last time, vote yes this time.
Yes.
There you go.
Member Garcia,
Aye.
Member Krajewski,
Aye.
Member Rutledge, Chair Tornatori,
Aye. Okay. Motion to deny is approved. Now, I'll entertain a motion to send the motion to send back to ZBA. Oh, okay. A motion to send this petition as set forth back to the zoning board of appeals for further hearing and evidence. There a motion? Or a second? A motion and a second to resend this back to the zoning board of
I
appeals.
would say that the discussion, I mean, the conditions are all good. I mean, cleaning up the site. I think the biggest thing for them to look at is the amount, the size of the property and the amount of animals the conditions allow.
And I think that, Paul, you will relay that information, that we're sending it back, obviously, to take a look at it in its entirety for those conditions or any others that may or may not come into play. Okay, so we have a motion and a second to send this back to ZBA for further discussion and hearing. Roll call, please.
Member Krajewski.
Aye.
Member Ozog,
No.
Member Garcia,
No.
Member Rutledge,
No.
Chair Tornatori,
Aye. And the motion to resend the ZBA is denied. So, Paul, when this comes to county board, is it going to come back to us in the three votes we just did?
Well, it'll just come with the recommendation to approve, which failed.
Was failed.
That's the only.
Because the recommendation to deny is the same thing as the denial of the approval.
So come
Okay.
forward in the affirmative, and that motion failed.
Okay. No, it doesn't need 14 votes, right? You said,
It does not.
because it's a conditional use.
Only a conditional use.
Okay, all right. Okay, I think that concludes that.
Chairman,
Yeah.
I have to excuse myself. I have a-
Oh, please don't go. Oh, no, me.
Starting to have fun. I apologize.
We still have a quorum. Okay.
Yes.
All right,
I
moving on
checked
to the
it, so-
second item. I'll entertain a motion to approve.
So moved.
DCO 002-22 Z21-085 Smuts, the zoning board of appeals recommendation to approve a conditional use for self-storage facility. A motion and a second. Any discussion? All those in favor?
Aye.
Any opposed? Motion carries. I'll entertain a motion to approve DCO 3-22 ordinance Z2187 as ZHO officer recommendation to approve a variation to allow a privacy fence. Second, any discussion, questions, comments? All those in favor?
Aye.
Any opposed? And the motion carries. Moving back onto, yes. Oh, okay. I'm sorry. That was this one. Okay. Right, Paul has just brought to my attention, and we discussed this, and I apologize, that the zoning board of appeals put a 10-year limitation on this self-storage facility. there is a, what, $7 or $8 million, this is a $7 or $8 million expense.
This is a tear down of an old hotel and a brand new $5 to $7 million building. That's what
And
we're
I think Paul brought it to my attention. I think it makes all sense in the world why somebody would invest $7 or $8 million and not know what's going to happen in 10 years. So I'm going to suggest that we remove that 10-year limitation from this recommendation for this conditional use and approve it without that
I'll
limitation.
make a motion to reconsider ordinance Z21-085.
Okay, there's a motion to reconsider and remove the 10-year limitation.
I think we motion to reconsider.
Reconsider, we'll take that first. Okay, all those in favor?
Aye.
Any opposed? All right, now we're gonna reconsider the motion. I'll entertain a motion to approve DCO 2-22 Z21-085. Is there an amendment to remove the 10-year limitation as set forth by the ZBA? Okay.
Build a big building.
Any comments, questions regarding? All those in favor?
Aye.
Any opposed? So we have it as amended. Do we not, Mr. State's Attorney? Are we okay with that? All right, good. Okay.
Thank you.
Moving on to informational. Let's before we, how about let's go with B first. I'll entertain a motion to approve and place on file TEP 8-22, a recommendation to approve a contract purchase order to Acela for managed application services. We've heard about that at Stormwater this morning, as well as Public Works. Any questions, comments? All those in favor?
Aye.
Any opposed? And the item will be received. Okay, the adult use cannabis locations. Paul's going to give us some information that he and staff have gathered regarding this. Just to be clear, our charge has been to take a look at locations. Ultimately, what we're going to hear today is where these locations would be available and with various limitations that we can decide or not decide, or recommend rather to the county board. It will then get referred to finance, who will not only look at these locations, but also the economic impact at the county on the number of licenses that we may get within these locations. Understand, there are, how many locations do you have there, Paul?
141.
141. The reality is here, the number of licenses are probably going to be 2 or 3. So the fact that there's 141 doesn't mean we're going to have 141 dispensaries if we want to make it that. So go ahead, Paul.
So this map is, I know it's a little bit difficult to read so far away, but we have it in your packet as well. We have it as a PDF. But what we've done, what we were charged with the Finance Committee and the original Development Committee on this was to look at properties that could be available in unincorporated DuPage County. And we put some criteria against the county. The criteria came from state statute, from our own zoning ordinance, and also some anecdotal information that came out of Finance and Development Committee. The first part was the state statute is that in the past, we've heard about the fact that there was a 1,000-foot distance requirement from protected uses, schools, daycares, other types of uses. That's been taken out of the statute. But what remains in the statute is that you can't advertise within 1,000 feet of schools and daycare facilities. So our first layer was to put a 1,000-foot distance from all schools and daycare facilities in the county. And that's both incorporated and unincorporated. And those schools and daycares are represented by bells and schoolhouses on the map. So the first cut is 1,000 feet away from those protected uses. The second cut is you have to be 1,500 feet away from an existing dispensary. We have 10 dispensaries in municipalities right now, and I'll get into that in just a second. But we put a 1,500-foot distance requirement or distance from all of the existing 10 facilities. The next cut that we put into play was that they needed to be on an arterial roadway. And the reason for that is that there was a concern in the the arterial roadway came from Finance and Development Committee. There was concern that we did not want these going through municipalities, the downtown core municipalities. Most principal arterials don't. There's only a few municipalities where they go directly through the arterial. The other concern was that anybody who would be using one of these facilities would not have to go through a residential neighborhood to get to the facility. The principal arterial obviously would allow people to come off of a tollway onto a principal arterial and not have to go through a residential neighborhood. So that's why we chose the principal arterial. Principal arterial is essentially a roadway that has 25,000 movements a day on it. It's a state roadway. Roadways like 75th Street, Route 53, 83, 59, and so on. The next cut that we took into consideration was that these were all going to be located in non-residential zoning districts. And the minimum lot size in the county zoning ordinance for a non-residential zoning district is 25,000 square feet. So we took out all properties that were under 25,000 square feet in a non-residential zoning district, our B1, B2, office, industrial zoning districts. And we came up with 141 sites that would be available that met that criteria. What we found was that, and it's a little easier to read obviously on your PDF, but we found essentially that you had sites on Lake Street, on Lake Street, on Army Trail Road, on Route 83, on Ogden Avenue, and then down on Route 59 in the Naperville area. And that's how we came up with the 141 sites that in theory could be available for a dispensary. This exercise did not take into consideration any additional zoning requirements that we might place on a facility if we were to cite a facility in the county, such as parking requirements and things like that. It just said it was a raw number, trying to find sites that could be available. Most of the sites that are currently operating in the county are concentrated on the southwest side in Naperville, and then the center of the county in Villa Park and Oak Brook Terrace and Lombard, and then up in Addison. There's a bit of a desert sort of in the northwest portion of the county in terms of municipalities. You may recall that when we first discussed this in finance, we had 16 communities in the county that had opted in, 17 had opted out. Of those 16 that had opted in, 7 communities had dispensaries right now. The other communities were looking to get dispensaries. There are 185 dispensary licenses that are available in the state. In our Bureau of Labor Statistics area, which is essentially Chicago, Naperville, and Elgin area, it includes all the typical collar counties that we know about: Lake, McHenry, DuPage, obviously, Will, Cook, Kendall counties, but it also includes DeKalb County and Grundy County. So in that area, we are allotted 119 licenses. And just to extrapolate the way that the license were issued on the first 75, we anticipate that our DuPage County area could get around 20 licenses. And keep in mind that of the 16 communities that have opted in, only 7 communities have licenses now. That means that the county would be competing not only with, the 16 communities, but the other communities that don't have licenses yet. There's a bit of an anomaly out here. We've discovered 10 licenses, and we've listed them in your packets where they're located. I'm advised that there's an 11th license out there somewhere. We haven't been able to track it down yet, but there might be 11 licenses in DuPage County municipalities right now. Of those 119 licenses that are currently auctioned off in, July, August, and September, there are 3 different categories. There are 36 licenses. And when I'm giving you these licenses, these are 36 of the 119. These are from the 119 in our Bureau of Labor Statistics area. We're considered District 5 for whatever that purpose is. There are 36 licenses that are being distributed for social equity. There are 36 licenses of those 119 that are being issued to what are called quality lottery candidates, and then there are 47 licenses that are issued to tied applicant lotteries. The difference between those three categories are that the social justice categories, you have to qualify for that. There's a whole myriad of rules for that. In terms of the 46 qualified licenses, those are people who have gotten, or those are companies that have gotten 85% or higher ranking in terms of their scoring for getting a license. So that they all went to a lottery back in July and September. And then the 36 license for what are called the qualified applicants are 36 licenses. Those are people who scored 85% or higher on their application score. Then the 47 tied licenses are people who were below 85%, but they qualified with a bunch of other applicants. So bottom line is there's 119 licenses allowed in our District 5 area, and they're being auctioned off in lotteries in these three different divisions. Once again, what we've concluded from talking to the municipalities and looking at how the licenses were distributed in our area before, we anticipate around 20 licenses available, and with the county and 16 communities competing for those licenses, which would likely mean that we would really only be available to get one or two or three in the unincorporated area.
But if there's 20 that would be available theoretically, and 10 that have already been granted, it's conceivable that the unincorporated area of the county could get the remaining 10 to the exclusion of the municipalities, could it not?
To be clear, the 10 are already through.
Right.
I'm talking about 20 additional.
Okay. So, but in theory, all 20 of those could come in unincorporated areas.
Absolutely.
But we'd be competing with our municipal friends and neighbors.
Correct.
Who are applicants.
Yes.
And who would be applicants.
One of the things we found too, in terms of, I don't want to get too far into the weeds on the revenue streams and the taxation streams. Finance is working on that.
Let me stop you one second. So before we get into that, and that's I think the crux of the whole issue. So how do you get to the 2 or 3 that are what you believe to be the number that we would have?
It's mere extrapolation based on the way that they were in talking to the collar counties, talking to the municipalities, the way that the original distribution was had from the 75 licenses that were originally available throughout the state. How many our area got? We got 49, and out of that, we originally had just 3 that we got. So when you look at the 119 that would be available across our Bureau of Labor Statistics area, District 5, we just basically extrapolated what we got a couple of years ago versus what we would get from the 119.
All right, I just want that to be clear to.
And it's not scientific at all. It's just based on some general stats that we took based on the.
I remember Chaplin's hand up first. So
Oh, well, thank you. And thanks. I appreciate the committee taking on this initiative, this project. So with regards to, the county competing with municipalities, what I look at is like the location. So somebody that's in the business probably is going to want to put their shop probably in what they view as maybe the best location or something they could afford. So, I think having more options for people to start these businesses throughout the county, is a better option. And also, with the municipalities, we don't want to take away from them, but I think it really is going to be, where these cultivators, I don't know what you call them, are going to, really where they want to set up their business. And how we do pre-engineering for jobs, and we say we're shovel-ready projects, so when grants come through, we're ready to go. Putting together something that would allow these dispensaries in the unincorporated area, I think is just being kind of proactive, and has more licenses come available, which I think they will as the years go on.
There's a total of 500 that the state has allocated for the lifetime right now.
So, as that number goes up, there might be more opportunities for, DuPage and municipalities. So I just think it's a good step to be proactive in this area.
I think you did a good job, Paul, on that. And I think, where they're gonna locate is gonna be where they think the high traffic areas are gonna be. So it's not necessarily compete against a municipality. Like I said, we got some on Ogden Avenue, but Ogden Avenue, we place don't wanna look, but it could be in the village or it could be in the unincorporated area. We got Lake, Army Trail 59, 83. Those are the places that they want to be because they're high traffic areas. It's gonna be whether they find one in unincorporated on 83 or they find one in the village of Darien or whatever. But I think you did a good job and, you know, you're gonna give them the option, but ultimately it's gonna come down to where they think the best, you know, location is gonna be. And like you said, where they're concentrated now, my guess is the next ones that come in are gonna look up in the northwest or the southeast corners, because that's where we don't have them. So the next guy that wants to come in is gonna, you know, look somewhere in DuPage. They don't wanna be next to each other. I mean, 1,500 feet, that's a good rule, except for the fact that if you're only gonna have 20 in the whole county, I don't think anybody wants to be 1,500 feet from somebody else. That's just cannibalizing the sales.
One of the things that's important to note, and we didn't include that in this study, but on the social justice, it's complicated, but on the social justice licenses, that 15-foot distance requirement goes away. You know, if it's a social justice dispensary, you can be closer than 1,500 feet to a dispensary. So there's a lot of nuances.
So I don't know if you need any more
I
action.
think maybe we have a quorum without, well, we'll
No,
make enough.
Information.
Thank you, Paul.
Yes, yeah.
Thank you, Chair. 2 questions, Paul. Have any of the municipalities that have opted out changed their mind?
Yes. Yes, and just to be clear, the numbers that I gave you, and we have more than, we have some peripheral municipalities that we did not include, like for instance, Elk Grove Village. There's a portion of that's in DuPage County. We did not include that in part of the 16 or 17. But the 16 that have opted in, of those 16, 10 of them had originally opted out back in 2019. So they've opted back in now.
All right. And then my second question is, when you identified these sites, did you look at dispensaries that were just across the border? Because I know there is a new one on North Avenue in St. Charles that's a stone's throw from the county line. So I don't know if that was part of your metric.
We did, and that we did take a look at that new one in St. Charles. And that St. Charles one is what's pulling basically everybody in this area over here, the one in St. Charles off of North Avenue. Just as an example, in Addison, Addison has 2 facilities. Addison has seen a bit of a drop in terms of their revenue and tax from those 2 facilities because of the expansion of the additional 7 from the original 3, 2 in Addison and 1 in Naperville, to 10. But also in Elk Grove Village and in Western Cook County, there are dispensaries now that are competing with the Addison dispensaries. And that's the same thing that's happening with the St. Charles and Kane County.
So any potential may kind of stay away from the county lines to get the biggest bang for their buck.
In addition, in Aurora, while Aurora has some in the county, they have some in DuPage County. They've got some in Kane County as well in Aurora.
Thanks, Paul.
Anybody have any other questions, Paul? Okay, so for the limited purpose of what we've been charged with to come up with these locations, we've done that. Again, I wish we could decide it here, but it's really not our purview. It's finance. From a personal standpoint, I think the big issue here is revenue and how much revenue we would be generating here at the county. Again, if we were to assume what we have in terms of revenue now and divide it by the number of licenses that we have, and then take that number, that's probably what we could expect for the 1, 2, or 3 that we would get in unincorporated areas. I don't think that if we have 2 or 3 more dispensaries that we're suddenly going to get a gigantic increase in marijuana use. It's just going to maybe get a little more spread out and diversified, which is, from my perspective, the problem that we might have with the municipalities, because now we're taking some things away from them that they otherwise had with our understanding a year or 2 ago that we weren't going to opt in. So that's going to be a political issue that we may have to deal with some municipalities. And as Paul has indicated, we've heard from some towns, one in particular, Addison, that has had a drop because as more dispensaries have come into play, they've lost the business. So I think that's a factor that we'll take into consideration as elected officials at the county, and then also the revenue that comes in, balanced with whatever costs may be involved in it as well, whether they be health costs, enforcement costs, et cetera. So Liz, your committee has this as a basis. At least we know where those locations may be if we ultimately decide to go that route. So thank you, Paul. Thank you, Jessica. Thank you, staff. You guys worked very, very hard, our GIS people, to get this. I think you've given us what we were asked to give finance, and we always try to please the finance. Sure.
Thank you. Thank you.
Okay, do we have any old business?
No.
Any new business? Okay, do I have a motion to adjourn? All in favor? We are adjourned. Thank you all very much.